Hello, everybody. Welcome to today's Provincial Training Conference session, Conversations about 60 Scoop and Day School Applications. My name is Kate Fish, and I'm the Online Community Manager for PovNet, and I'll be your moderator for today. I use she, her pronouns, and I'm a settler of European ancestry. This afternoon, I'm joining you from Courtenay, the unceded traditional territory of the Comox First Nation, which is on Vancouver Island. And this is an area that the Comox people refer to as the land of plenty. And I'm reflecting on that quite a bit these days with gratitude for them kind of tolerating us being here on this land that has been so abundant over thousands of years. Please feel free to share in the chat what territory you're joining from to see where you're coming from across the province. So today's session is designed for advocates working on issues related to the 60 Scoop and Day School applications. And the hope is that there will be some discussions after the presentation with the speakers today. And our speakers today include Gloria Cardinal, a legal advocate and legal assistant with the Indigenous Community Legal Clinic, where she has supported clients' applications for both the 60 Scoop and Indian Day School class actions. We also have Jaden Bourque, who with the Indigenous Community Legal Clinic as well. And finally, we have Caity Goerke, a sole practitioner who brings her experience in family, child protection, and Indigenous legal issues to the discussion today. Before I hand it over to the speakers, I just want to go over a few logistical details. So today we have Anna from the Law Foundation and Nikki Dunlop from PovNet Society providing tech support for this session. They're both available to monitor the chat and make sure that if you are having any tech difficulties, that they can support you with that and get them resolved as quickly as possible. If you have any issues, you can ask for help in the chat or by messaging Anna or Nikki directly. Thank you for providing tech support. This session will be recorded and resources and presentation slides have already been uploaded to Sched. If you have any questions for the speakers, please write them in the chat and I will make sure to collect them and field any kind of time-sensitive questions to the speakers as relevant. Otherwise, after the speaker's presentation, I will be posing the questions to the speakers, but you will also have the opportunity to come on video to ask the speakers directly yourselves. And we'll be doing that. I'll be kind of asking you to say, can I come on video, please? And that will indicate to me that you would like to directly ask the speakers your question. Okay, I think that covers it. I will pass it over to the speakers now. Thank you.
Hi, everyone, and thanks so much, Kate, for that introduction. I'm going to go ahead and share my screen. We've got a PowerPoint today. So let me just get this up and running. Kate did a wonderful job. Thank you introducing us. So again, my name is Caity and I'm a contract lawyer and I'm working with the Tira Women's Resource Society right now with claimants for both 60 Scoop and Day School's class actions. As Kate mentioned, Gloria is a legal advocate and legal assistant with the Indigenous Community Legal Clinic, and she's been doing that work for over 3 years and has worked extensively on both of these class actions and is by all measures an expert. So we're feeling really fortunate to have her here today and excited to have Jaden join us as well. Jaden was a legal assistant and is now an articling student at the Indigenous Community Legal Clinic. And he is a proud alumnus of the Indigenous Legal Studies program at the Peter A. Allard School of Law. I'd like to take a moment today before we get started just to recognize the unceded ancestral and traditional territories of Indigenous peoples across the land that we commonly refer to as British Columbia. I know today that we're joined by participants from across the province, but I'd like to especially recognize and acknowledge the Coast Salish peoples, including the Musqueam, Squamish, and Tsleil-Waututh people, on whose traditional territories both the Indigenous Community Legal Clinic and Atira are located. And as we go through today's presentation, I do really encourage all of you to think about the history of the land that you are on, and just be mindful that across BC there were 112 federal Indian day schools, and that the ongoing impacts of destructive child apprehension policies such as the 60 Scoop continue to impact Indigenous communities and families across the province today. So we're going to talk mostly about the day schools class action, but we will also mention 60 Scoop, and happy to field questions about 60 Scoop as well. Here's an agenda for today. So Gloria and I are just briefly going to talk about 60 Scoop, some dates, what's been going on with interim payments, collectiva, and then we'll focus on the Federal Indian Day Schools class action. So we'll talk about the claim forms, drafting the narrative, witness statements, trauma-informed interviewing, and then just provide an update on how the claims process has been going so far. So the 60 Scoop, the deadline for applications was on, did end on August 30th, 2019. There was a period where late claims were being accepted up until December 2nd, 2019. When we sort of were chatting amongst ourselves, Gloria and Jaden and I, we, all want to acknowledge that, it may be possible for a 60 Scoop claimant to make a late application even now if they have, they're able to provide a reason like undue hardship or something in their life that prevented them from making the deadline. And so happy to, connect with advocates if folks do come forward with 60 Scoop claims that they weren't able to make within the claim deadline. An update on the interim payments, because if you've worked with 60 Scoop claimants, you may have heard about this. So the reason why full payments haven't been made to, I should say, so out of the 34,767 claims that were submitted to 60 Scoop, only 12,551 have been processed. And so out of those, there's a set of obviously the eligible claimants, and they've been given interim payments of around, I think it's $21,000. The reason that full payments haven't been made yet is because the total amount of compensation that each claimant is going to receive depends on the total number of eligible or total number of claimants who are found eligible for the class action. So they've just started to make interim payments over this past summer, and any claimants found eligible from this point forward will be eligible to receive that interim payment until they're able to determine what the final amount will be. Many of you may have had the experience over the last year of trying to communicate with Collectiva, who are the class action administrators for 60 Scoop. And you may know that it's been a challenge to get a hold of them to get updates for claimants on their claim status. Collectiva did recently make an announcement that they have added capacity to their call center. And I actually have noticed just personally that some of my emails are finally being responded to. So hopefully that will help with the backlog, and we will start to get answers for claimants as we connect with Collectiva. But, I think it can be helpful to just share with claimants that this process is taking a really long time. If you look at the numbers, only a third of claims have been assessed in a year. So, unfortunately, I think folks are still going to be waiting a while to hear decisions just based on whether or not their claims have been looked at by the administrator yet. In the meantime, some claimants have been receiving letters, and so you may have had clients come in with letters from Collectiva. So the notice of eligible class member letter is the letter that is essentially an acceptance letter, so saying that that claimant's been found eligible for the class action, and that letter should be followed up with an interim payment. You may also have clients who've received a notice of intent to reject. This letter comes prior to the official rejection. And the important thing to remember here is that claimants have the opportunity to apply for reconsideration. And so you can support them to do that when they get the notice of intent to reject, and just be mindful of deadlines. A lot of the deadlines, I think actually they've suspended rejections for the moment because of COVID, because COVID has slowed down the process of getting records from government. So if you do have a client who's worried that they've missed their deadline, it's worth getting in touch with either Collectiva or you can contact Class Counsel in BC, which is Klein Lawyers.
Caity.
Yes.
Sorry, just got a direct message asking about what made those particular claims not eligible.
Oh, okay. So there would be a mix of reasons that claims wouldn't be found eligible. I think, most commonly it would be that individual didn't meet the eligibility requirements of the class action. And so that could be that, the time that they spent in government care may not be sufficient to be found eligible. And so on that note, the class action, the exceptions committee for the class action has found that a claimant needs to have been in government care for at least 5 years to be found eligible. So it's possible that could be a reason to reject. I know in my own work that clients have received notice of intent to reject letters based on not having status under the Indian Act. And it may be that they just need to provide additional information in order to have their status approved. And then I think the request for additional documents is likely also a reason. So you may get a letter asking for those additional documents, and if a claimant is unable to provide them, that could also be a reason for a rejection. And maybe actually I'll pass it on to Gloria there too, to see if she wants to add anything to that.
Yeah, I do want to make a few statements about this. So we have had a few clients that have come through that have been rejected. One of the clients, his specific reason was that he was put into adoptive foster care 2 years before the settlement agreement started, even though he was in foster care for 10 years. Like I think it was from 1949 to 1956, but because it didn't fall within the strict deadlines of the settlement agreement, he was denied, which I really didn't think was fair. And so we're trying to find a way to appeal that decision, because he fits into the agreement and what was determined as, as far as I'm concerned, he is an eligible class member, but because he was in foster care a year before the actual settlement agreement, so it's things like that. Like sometimes it's based on what the settlement agreement says. One thing that we get a lot of clients that have dropped in the last, I'd say the last 2 months, I've had a lot of drop-in clients who said they never heard of 60 Scoop until just now, and can they apply? When these clients come through, I say to them, you know what, you can always try, because on Collectiva's website, there is a form that says reasons for late submission. And that form was created for those claims that were meant to be put in before December 2nd, 2019. But it is because of exceptional circumstances in a person's life. And so I say to someone, I'll give you the claim form, to apply the application form, and I'll give you this reasons for late submission. And I said, put down much detail as you can about these reasons, because if the administrator looks at it and they say, okay, these reasons are sufficient, you never know, they might accept it. Now, I've probably given that out to 20 plus people within the last 2 months. And sometimes we fax in these documents for people as well. Collectiva has never responded. So as far as I know, you know what, they shred them, right? But I just feel like if someone wants to apply, I think they need to try, because we don't know what the ultimate outcome would be. So I always encourage people to do that. Another thing, a letter that's come in quite recently, it's called Request for Additional Information, which is alluded to here. And basically what is asked for, they asked for a witness to attest to the fact that this person was in foster care. So one of our clients, this was a month ago, he came in, he had this letter, and he said, he said, my foster parents have passed on, but the siblings, there was 7 foster siblings that are still alive as far as I know. And so I went, onto Google and searched, and I found one of his foster brothers who lived in Winnipeg. I faxed, I found contact information through 411.ca, and just in phoning people and saying, could you support this person's application as a witness? We got to submit that information to help our client in order to give that additional information. And so that's the kind of thing that we do. We call that summary service because it's something that we can do within 1 to 2 hours. And we do as much as we can when they walk in the door. And so that's the kind of thing that's been happening since the end of the 60 Scoop. And I have a lot of clients who haven't heard anything. And every time they come in, we send in a fax. We just ask for an update. Collectiva really doesn't respond, and it's because they don't have capacity right now. But as we've noticed in the most recent update, they now have other people who are hired to help continue to process these forms, because they're really only 1/3 of the way through, which is not a lot. So we just hope that they can finish processing as soon as possible.
Yeah, thanks so much, Gloria, for jumping in. Oh. And, I just would echo in the work that I've been doing at Atira with 60 Scoop claimants that, I've, worked with a lot. Many of the claimants that I've worked with have not heard anything from Collectiva yet. I think that's kind of important for folks to know, just because I think a lot of people who applied are nervous or panicked about the fact that they haven't heard anything yet. And, unfortunately, this is really the nature of class actions, that they tend to take much longer than ever anticipated. So, I think there's a lot of people waiting to hear an update. And the best you could, sorry, Gloria.
Okay, just one more thing I forgot to mention. As far as extensions go, when some of our clients are looking for a community that they are connected to, but we haven't found it yet, Collectiva has told us that basically the extensions will continue until we find out whether we can get them to get their status or to have them connected to a community. So that has been something that Collectiva has corresponded with us. So we continue to ask for extensions whenever it's needed.
Great. Yeah, great. Thank you, Gloria. And I would encourage and obviously we're happy to take 60 Scoop questions, now or at the end. But I would also just encourage folks, the last slide has contact information for myself, Gloria, and Jaden. And, I think we're all happy to chat with other advocates around the province where there's questions about the letters that folks have been receiving or other 60 Scoop related questions. Okay, so we'll move on from there. I just, and before I start talking about the day schools class action, I just want to acknowledge the painting that we've put up on the slide. And so this painting is by a local artist, Lawrence Paul Yexwell-Upton. It's called Portrait of a Residential School Girl. And Lawrence Paul Yexwell-Upton attended a residential school in Kamloops. And this painting is in honor of a schoolmate of his who passed away while at the school. So the Indian Day Schools class action was started, or its inception was in 2009 when the named plaintiff, Gary McLean, launched a class action lawsuit against Canada. It wasn't until 2019 that the federal court approved a nationwide class action settlement. And so now that the class has been settled and there's a settlement agreement, we're now in the stage of administering the claims. And so claimants have from now until the official date is July 13th, 2022, although the class action has committed to making a 6-month extension available because of COVID. Have until 2022 to make those claims. And to be eligible for the Day Schools class action, and an individual must have attended one of the identified federal Indian Day Schools that are listed in the settlement agreement and experienced harm in that school. Just a note on that. I know that I've talked to Gloria, and I don't know if she wants to jump in here, where someone may come forward and have attended a day school that wasn't on the list. The settlement agreement states that a claimant must have attended one of the listed schools to be eligible for the class action. But similar, I think, to the work that Gloria has been doing in, giving people information about late applications to 60 Scoop, it may be worthwhile for a claimant to make an application if they attended a different day school that's not listed. And there may be reasons why that school is not listed that, can be considered by the exceptions committee.
Yeah, so I will jump in here a little bit. What we tell clients is that we want them to apply regardless of whether their school is on Schedule K. And one of the reasons is that if, say at the end of the class action and they have, 12 to 20 people who have listed a school and it's not in Schedule K, the administrators are going to take a look at that and likely approve it because, there's enough people that support that school was open. Also just because they've already established an exceptions committee and they've specifically spoken to that issue, that they will look at every application where the school is not on Schedule K. So we definitely tell people to apply even if the school is not on Schedule K.
Thanks, Gloria. So we mentioned the exceptions committee. So I just put this up as a little who's who, because if you look at the claim forms, you'll see these different terms. And if you're not familiar with class actions, it helps to sort of understand the different roles. So Deloitte has been contracted to be the claims administrator. So similar to how Collectiva has administered the 60 Scoop claim, they will be administering the Day Schools claim, which means they're sort of the first line of assessment. And so it's their role to assess claims and to either approve the compensation level that the claimant has indicated that they meet, or they can lower or increase that compensation level as well if they think that the claimant fits into a different level. And we're going to talk about the levels in a little bit, so that will become more clear. Now, so there's also a third-party assessor. And I just sort of found this out today. The third-party assessor is a lawyer, a mediator, and arbitrator from Ontario. Her name is Reva E. Devins, and she has been an assessor on multiple class actions before. And so it's her role where if a claimant and the administrator disagree about the level of compensation that claimant should receive, then that claim will go to the third-party assessor, and it's her job then to determine whether she agrees with the administrator or the claimant. And in unique circumstances, the third-party assessor will pass a claim onto the exceptions committee. And so the exceptions committee are there to help determine questions of eligibility. And so exactly like Gloria was speaking about before, those questions around if a claimant doesn't fit obviously into the eligibility requirements of the class action. So that would be if they didn't, for example, they didn't attend one of the listed schools. The role of the exceptions committee is to determine whether an exception should be made for that person. So that's what they do. Class counsel for this class action, it's there's unlike 60 Scoop where there was class counsel for every province. We have one class counsel for this class action, and it's Gowling WLG. So all claimants across Canada are entitled to receive support and advice from class counsel. And they're entitled to receive that support free of charge. And so you can always refer clients that come in to see you to Gowling. I haven't heard any feedback from any claimants who have worked with Gowling, and whether or not that's been supportive or helpful. And so, I think that's part of the work that I'm doing and that Gloria and Jaden are doing is providing more community level service for folks that may be a little bit more catered to their needs than just calling in to the call center at Gowling. So it's there, but I can't say for sure whether or not it's a supportive resource. And yes, okay. And so the exceptions committee I mentioned, yes. And so just on that note, so another kind of claim that the exceptions committee may look at is where the harm experienced by a claimant doesn't fit into the harms grid that's provided within the claims form. Again, we'll chat about that. And so, again, just really encourage anybody to apply, even if they don't obviously fit into the eligibility requirements, because that's what the exceptions committee is there to do. So on that note, I'm going to pass it on to Gloria, and she's going to talk about the claims form. And Gloria, feel free to just order me around when you need to move the slides.
So we had asked the group of you to watch the webinar that Jaden and I prepared in, I think it was July 2nd, 2020, I think we presented. And so we're hoping that you took a look at that. If you didn't get to watch the whole thing, it's available to watch after this. And it takes you through a history, the claim form, the narrative, similar to what we're doing today. And so I'm just going to get into, so the claim form itself, I'm not going to walk you through each page, but what we want to do is kind of talk about it in general terms, just to give you an idea of what to expect if you are helping people do a claim form. And I'm speaking to legal advocates. You have people that come in that maybe they just, they get intimidated by doing paperwork, and they just want to make sure that it gets done right. So they approach you because they want to make sure that everything is being handled, in a good way, and that they're not missing out on anything. And so what we're trying to present today is tips that we've learned along the way in helping people prepare these forms. They could be from level 1 to level 5, and just kind of what we've learned. And so first, I'm just going to talk a little bit about the basic information. And so this is located on pages part 1, part 2, and part 3. So the initial part includes the basic information, contact information, date of birth, status card number, social insurance number, and how to contact someone by phone, by email, and by address. So, and that is pretty standard in most application forms. You always have the contact information and the proof. Now, what we do when someone comes in our doors, we take their ID and we photocopy it. We do it in color, and we try to have everything on one page so that it's easier to read. And then that is for the client to or for us to attach when we mail or email this claim form in. This part 2 is where and when did the client attend the school. And so from here, we just take this information from the client. We ask about the school they attended, the nation that they're from, the first year that they attended, the last year that they attended, and so on. And we add the number of schools. So if there's one school, it's one school. If there's two schools, it's two schools. And if there's three schools, we usually just attach a separate piece of paper with that typed onto in the same format as day school 1 and day school 2. So far, in talking with clients, I think I've only had one that has attended 3 schools. Most people have attended 1. Some have attended 2, and occasionally you'll have somebody that attends 3. So generally, this page, part 2, is sufficient for probably 99% of the people that are applying. A little note about the day school is usually listed in Schedule K. Schedule K is on the website and is a huge document because it includes all of the day schools across the country. Generally, we're referring to the ones in BC, but we help people from across Canada as well. So sometimes it could be that someone's from Manitoba or Saskatchewan, and so their day school is from there. And so we just enter that information. Sometimes clients don't remember the year they started, but they remember that it was kindergarten or grade 1. I use their date of birth and I count forward 6 years and I use that year. So that's how we determine the first year attended if the client does not remember, and we use that date. So we just use their date of birth counting forward that number of either 5 years if they were in kindergarten or 6 years. So we just make it as practical as possible. And then we have part 3, which is the consent and signature page. And this page is meant for us to read through to the client that they have included everything to the best of their ability and that it's all true, and that they also have not received any other prior settlements in relation to any other class actions, such as the Indian residential school payment. And so you have to check the box no, and then our claimant has to sign and date it, and then generally we can act as the witness, and so we sign and date it, and give I usually give my work address and my work phone number and my work email. I include all of that information, and it's the date that we actually sign in the office here, or sometimes virtually. But the ICLC, we have drop-in hours now during COVID. We have strict COVID policies around having clients enter, but we're doing so because we need to sign documents like this, and a lot of our clients just don't have access to computers, and they don't have Zoom, and they can't sign on a PDF and that sort of thing, which many of us can do through our work and things like that, but our clients don't have access to that. And so we have open hours available for our clients so that they can come in and sign the forms, and that we do that here at the office. One thing I wanted to say also about the claim form, I recently went onto the website because I wanted to take a look at the updates. And so one of the updates was that to date, 89,140 claims have been received, and that they've already paid out 34,227. And that's a significant number. I was actually quite surprised that they had already paid out that many claims, and which means that there's 54,913 that are still in progress. But I pretty much take that to mean, so approximately 40% of the claims that have already been submitted have been paid out. I think that those claims are level ones. So I'm thinking that probably about 40% of the claims that they're going to receive are going to be level one claims. In the paperwork, it says, in the timelines, it says that it takes about 6 months, up to 6 months to process a level one claim, and it takes up to 12 months to process level 2 to 5. And so because level one is the easiest one to apply for, that is why that the turnaround time can be so fast. And so that's why they've already processed just up almost 35,000 claims. So Caity, let's go to the next page. Okay, on this next pages, which is part 4 and part 5, it lays out for us the claims process for levels of harm. Level 1 is it's the verbal and physical abuse or harm. And the verbal and physical abuse includes mocking or shaming or humiliation by reasons of Indigenous identity or culture. So being made fun of for being Native, being not able to talk the language, being told that they're a dirty Indian, different things that are talking down about the culture, making fun of the way that, their cultural songs and dances and things like that, threats of violence or intimidating statements, sexual comments or provocations. And then in level 1, it also says, or physical abuse or harm, including unreasonable or disproportionate acts of discipline or punishment. Now, in a lot of the claims that have come through our office, when people are claiming a level 1, a lot of the physical harms that come to people, or that it's the discipline that we get told most often, is that people were pulled by the ears, they were hit on the back of the head, they were made to kneel in the corner or at the front of the room for long periods of time. It's that sort of thing. It was called discipline. It's very abusive, and it was very painful for them because, and it also included having to clean the washroom stalls on your hands and knees, where you had to scrub the floor for hours, where they would be cleaning for hours. This is the kind of thing that is some of the stories that come through when we are actually doing the actual narrative of the claim form. When we get on to, when we get into the upper levels of harm, it definitely includes more serious things that have happened to people, and it can either be in the sexual abuse, sexual incidents, one or more, or repeated ones when you get up to level 5. Physical abuse, where it says there's at least one incident of physical abuse, or when you get to upper levels, it's repeated incidents of physical abuse. And we've had some issues here in determining levels of harm, just because it's really hard sometimes to make a distinction. When someone is being verbally abused and physically abused, and how do you make the distinction between level 1 and level 2, or level 2 and level 3? I mean, it's a very fine line. And the thing is that it's hard to, even make that call. We just try and use the best judgment that we have, because listening to someone's stories, that when they're talking about these harms that have happened to them, it's difficult for them to talk about. It's difficult to hear and to write down if we happen to be making a narrative that is to be attached to a claim form. We have tried to be as specific as possible about, incidents that happened, dates and times, patterns of behavior, who it was who was the person in authority who was instigating the harm on the student. We try within our interviewing and in our process to just be as detailed as we can, because we think that it is so important in relaying this narrative that we are, putting our clients, this level at the correct place. So, as at the ICLC, we've had discussions about, about how do we categorize levels of harm? What are we saying is the level 1? What are we saying is a level 2? What are we saying is a level 3? What does that look like? And so we do have conversations about that among coworkers, because we just want to be respectful to the client. We want to be inclusive of everything that they're saying, and we want to be able to put their story into this, the description of what has happened, as these abuses have happened. We want to take those descriptions and accurately represent that within the process of the narrative. This is the most difficult piece of doing an Indian Day School application, is this part, the compensation levels and how to represent it the best way. And a lot of our clients, like I was mentioning about, they've had 40% go to a level 1. A lot of times our clients want to choose level 1 because they don't want to talk about the experience that happened at Indian Day School. They just want to put in the application and that's it, because it is the easiest thing to do. And they maybe were a person who experienced things at level 3 or level 4, but they don't want to bring it up again. They don't want to talk about it, and we understand that and we respect that because it's difficult. So, we just try and be as compassionate as we can in moving through this claim form, and especially this, parts 3 and parts 4 and parts 5, where it's talking about levels of harm. We have to be very understanding, and but we still try and be as a collector of information in the best way that we can in order to represent what the client has said to us at the level that it should be. There's one thing that I want to mention that's in the settlement agreement, and it's Schedule C. There's a page, and it's called Schedule C, Survivor Class, Section 44. And I'm just going to read a part of this. It says, as a consequence of the negligence and or breach of fiduciary, constitutional, statutory, and common law duties and the breaches of Aboriginal rights by Canada and its agents, for whom Canada is vicariously liable, the survivor class members, and that's who we are representing as the survivor class, the survivor class members, including the representative plaintiffs, suffered injury and damages, including. Now, in this list, it goes from A to V. It has assault and battery, sexual abuse, severe emotional, psychological pain and suffering, loss of language, culture, spirituality, and Aboriginal identity, isolation from their family, community, and nation, an impairment of mental and emotional health, in some cases amounting to a permanent disability, an impaired ability to trust other people, to form or sustain intimate relationships, to participate in normal family life, or to control anger. Now, that's just the first 8 damages that are mentioned in Schedule C. So, when we're working through, part 4 and part 5 and these different levels of harm, we as we're interviewing our clients, we keep in mind, that they may have said, I don't really remember too much that happened, but down the road, they talk about, I didn't really have a career, and I didn't get to, I didn't get to attend the college program that I wanted because I was never, when I went for I went for the testing that with my band, and I only came out at grade 3, so I couldn't get the training for a technical program. A lot of these things that work out in someone's life down the road are a direct result of the experience that they've had in Indian day school. It's because, they had a loss of self-esteem and feelings of degradation, shame, fear, and loneliness. They were deprived of an education, including basic literacy and skills necessary to obtain gainful employment. These are suffered damages that are included in Schedule C. And we always need to be listening for that whenever we're listening to someone tell their story. We need to listen for those things, because that will help us determine at what level of harm it is. Someone they say I'm a level 1, I was mocked, and I was, made to, kneel in a corner because I, spoke my language. And so I did, I had to do that many times. And I couldn't speak my language, and me and my sister couldn't ever speak because, they knew we would speak our language. And so they kept the family members apart. That may sound like a level 1, but when it leads to, an impairment of the capacity to function in the workplace and a permanent impairment in the capacity to earn income, or it says an impaired ability to enjoy and participate in recreational, social, cultural, athletic, and employment activities, those are huge harms. Those are not level 1. Those are higher than level 1. And so, we've, at the ICLC, we've taken time to really read through the settlement agreement to have a real understanding of that settlement agreement. We've read through the claim form. We try and have an understanding of, Schedule C and what it means as people are talking about the narrative. I mean, we try and be informed about this whole process, so that when someone comes in to apply and they say, I want to be a level 1, that they are understanding, that they've experienced some extreme loss as a result of Indian Day School. And maybe it was, mocking and feeling ashamed of your culture and being intimidated by people or having threats. But down the road, it led to huge losses. It led to losses of education. It led to losses of opportunity. It led to losses of relationships. It led to loss of communication with people because, you were never confident enough to speak up for yourself. And it's because of Indian Day School. And so, we try and keep these things in mind when we're filling out the form. It's a complicated process, and the settlement does speak to a huge range of levels of harm. And the form, to me, it's not really that descriptive. So when you're preparing to help people do this application, go into the settlement agreement, find Schedule C, read through that, and just think about how did the survivor class member that I'm dealing with, what kind of damages did they incur, and how have these different things, A to V, how has that worked out in their life? And then how can I represent my client and help him or her to complete this application so that we find the right level of harm for that person. Okay, Caity, let's move on to the next one. So the next parts, part 5 and part 6, are about finding the supporting documents. Here where I'm working, when we open a claim, more and more we're beginning to do an ATIP request right at the outset, because we want to try and find as much information as possible for our client as we can. And these things take time. So I know that this is another thing that we also have to think about when looking for additional information. Sometimes school records are not that easy to find. Someone came here this week and had school records that the school had sent him, and he had it attached to his claim form. And I thought that was excellent, because I think it's very difficult to get school records. I think it's hard to get attendance records, from the 50s and 60s. It's difficult because schools and different places haven't kept them. So these things we're just trying to do as much as we can. A lot of times another thing is you have to do, let's say the written narrative. I'm going to leave that for now. I'm going to let Jaden talk about that, because we'll get into that quite extensively down the road. And I think I've talked about it. I've alluded to it a little bit in doing the interview and into determining levels of harm, because it does come through the written narrative. So we've got identification. That is the easy part. We photocopy that and attach it to the application. The written narrative. This can sometimes take 1 to 2 to 3 interviews, depending on the person. Sometimes there is no interview because someone doesn't want to have a narrative. And if you are at level 1, it does not have to be included. And that is the choice of the client. The next thing, list of position and persons who inflicted or caused the abuse or harm. Some people can remember the name of the teacher or the principal or the official who did the harm to that student. Some people can't. And so we just include what the person has said to us. If it's a name, we include that. And if the person doesn't know, we just say unknown or cannot remember. We just write that down in the form. The evidence of school attendance is a required thing, and this is something that we are trying to find for our clients, and it takes some time to track these documents down. Now the next one, we've had a lot of success doing witness narratives. We'll get to that in a few slides from now. I'll walk you through just one of the claim forms that we submitted in July and what we attached to it, and what that looks like. And then medical, dental, nursing, or therapy records. We've attached doctor's notes. Sometimes we attach therapy notes. For one particular client, I attached educational records, because the person who had gone to Indian Day School and was trying to, heal himself from the harms that he had experienced throughout his lifetime and at that school. He went into counseling. He first taught himself to read at the age of 45. Then he went to school. And at this point now he's taking a master's degree and it's in counseling. And he said, I'm doing it because I'm just continuing to heal myself from the effects of Indian Day School. And so I attached his certificates and all of his attainments at each level of education to his application form, because it was proof of healing. So we have to sometimes think outside the box in the way that we approach what does someone's healing look like. And that's why, and that's another reason that the narrative is important, because it's in these conversations that we find out, this person, he never went to see a counselor, but he's, spent, 20 Sundays going to the sweat lodge and did this and this and this, so there's things that people do in order to overcome the harms of the past. And those are the things that are important to include in these application forms. The last page, part 6, the sworn declaration. When we have our lawyers sign the sworn declaration for some of our claimants, and it said that it has to be a notary public or commissioner of oaths. It says including people who are like chief and counsel, so people who are part of the administration in some northern villages and different places. It has to be an elected official or community leader, or other professional, example lawyer, doctor, physician, accountant. we have our legal director sign for the people that are finishing the claims off right now. And he's, that's to us what we want to do the best that we can for our clients. And so whenever someone wants to sign, I make an appointment for the legal director to be here, that we can have this paperwork signed and sent off as soon as it's completed. We have an appointment for tomorrow. Someone's going to come in and do the narrative, and then we want to finish the document and have it sent off tomorrow. So I've made an appointment for the legal director to come in at 3, and we're going to sign. And so we just, we try and work through every step of these applications in order to make them completely complete. This next page, the representative claims, it's talking about the representatives of a deceased claimant's estate that they may make on behalf make a claim on behalf of another person who has already passed on. The person has to have deceased after July 31st, 2007. And the reason for that is that is the limitation date of the class action. So this date is specific to when the class action was filed. So if someone passed on in 2002 or 2003, they wouldn't be able to apply for this class action. This next thing, the legacy fund, it's a settlement that includes a $200 million legacy fund to support commemoration projects, health and wellness programs, truth-telling events, and the restoration and preservation of Indigenous languages and culture. This hasn't been established yet. The legacy fund will, I think it gets established, well, hopefully sometime within the next year, and I'm not sure if they wait till after the deadline of the application period or not. The legacy fund will be a fund that people can apply to. It's almost like a granting program where you can apply, a community can apply for funds and, create healing and wellness programs for the community in relation to this Indian Day School. And it's open to anyone. It's open to people who, so the survivor class, it's open to their children, to their relatives, and to people who are related to the survivor class can apply to the legacy fund in order to create, like they say here, health and wellness programs, different projects and stuff like that. Next slide. So I wanted to walk you through in just a few pages of what does a finished package look like. This would be level 2 to 5. The package that I'm going to walk you through is a client that we submitted this at the end of July. It had a narrative. It didn't include doctor's notes or medical records. It included a picture from the school days, and it included a couple of affidavits. So let's go to the next slide. So the first thing was the narrative. This narrative was done by one of the lawyers that worked here between January and April of 2020. This was one of the first Indian Day School files that we opened. I think that this clinician met with the client about 4 or 5 times, and so she put together this narrative, and it just basically walks through her experience at school, her experience, with her career, and working through, and just some of her feelings about the Indian Day School and what happened to her, and some of the levels of some of the harms that happened to her while she was there. Next slide. Of course, I'm showing a picture of the copying ID. Just as an example, we copy the ID, we try and do it in color and to have both sides on one sheet. It makes it easier to read. This person wanted to include all of their status cards. We would have only needed to include one of these. You don't need to have multiple IDs. You need to have one government issued ID. It could be a BC ID, and this is the status ID. Next slide. I referred to this a little before, the witness statements. So the witness statement is an important way to make the narrative more powerful. At the ICLC, we choose to use the affidavit as a way to include the witness statement. These can also be done remotely by following the rules. The rules are, I think it's listed on the Law Society webpage, the rules for doing remote affidavits. And I could find that if someone's interested in that specific information, you could get a hold of me after and I could send that to you, because we made sure that we went in and looked at what needed to be done to each, to the affidavit as it was being done remotely. So this client, she had her sister make a statement because her sister had witnessed what went on in the school at that time. And then we also found she had a friend who was in the same grade as her who had witnessed the events of what happened to her. And so she also swore an affidavit as to the facts, as to what happened to our client at the school that was in Lake Babine. And so, yeah, this is just a sample to show you kind of what that looks like. Next slide. So then this client, she had a picture of herself and her classmate along with the nuns that are in the background there and the class that was taking part in doing some sewing. Next slide. And so that was just to show you, take you through what a package looks like. We started that one, I think, in April. We finished it off in July. And yeah, so that's just to give you an example. I'm going to turn it back to Caity and we will talk after during question and answer period.
Thanks so much, Gloria. And I'm actually just right away going to pass it on to Jaden. He's going to do the next couple of sections for us.
All right. Thank you for going over all that, Gloria. That's very intense to go through the forms like that. I guess people can probably sense that this is there's a lot to this process. Now, speaking of this process, it's the narrative component where the heavy lifting is done. Like Gloria had mentioned, we at the ICLC, we try to do a narrative for absolutely every claimant who walks in the door if they're willing to do so. And that's solely because we really want to know what to determine the harm level at. And in many cases, we find that the client coming in really doesn't know the significance of the harms that they've incurred. That's happened on most occasions that, most clients I've had to work with. They were quite far off on their own assessment because I hadn't considered some of the after effects of day school, all these harms that, they really incurred at day school, and it carried on with them for life. That's why Gloria took the time to go through Schedule C, Section 44, which has a very comprehensive list of harms, as opposed to what you see on the claim form itself, where, it's kind of vague, honestly. It can be very difficult to make your assessment as to what that level of harm was. So you see here, we note, again, yes, that not every claimant realizes their level of harm. And one of the things about the narrative component is we're working in a very colonial process with this class action settlement. So one of the things that we can do is, this is our one chance within the whole settlement process to actually indigenize or decolonize the process. So we really treat this narrative component as an exercise of truth gathering or truth sharing, which is, we've seen this with the TRC, we've seen it with the Missing and Murdered Indigenous Women and Girls Inquiry. It really is crucial to engage in that truth telling. At the end of the day, the compensation is pretty inadequate. If you look at a level 5 claim and it's maxing out at $200,000, to reach that level in the mind of the assessor, it's just atrocious, the harms that a subject would have had to endure. So one of the things that we can discuss with the client is, maybe there's a chance to heal with this truth sharing, right? And at the end of the day, some of them, that's good enough for them. If that's all that they could have as a fallout of this settlement, that'd be enough for some people. Now, we always do have that conversation. Again, it's very inadequate, the compensation. And we find that when we finish up with these narratives, some of these clients, they want to use these narratives to maybe have that discussion of their life history with their children, perhaps grandchildren even, gets a better understanding of this, why things might be dysfunctional in that family. The intergenerational trauma is absolutely huge. I mean, I can speak to that from personal experience. I know Gloria can speak to that. Most Indigenous people can speak to that, the breakdown in family. For instance, my grandma attended day school in Fort Vermilion. My grandfather attended residential school in Lac La Biche. My dad had a horrendous upbringing, developed a real quandary of identity from that intergenerational trauma. He was really forced to try to hide who he actually was and to never mention that he was Indigenous, if at all possible. So again, this is significant. This is going to be the most time-consuming part of the whole process. And, it requires several revisions. It requires an in-depth discussion and connection with your client. We could go on to the next slide, Caity. Okay, here again, we're mentioning the truth-telling and the truth-gathering. And, I like this image a lot. We can see very clear depiction of that emotional scarring when we look through that image. We're actually going to go to the next slide. And this is the other thing that you guys need to be cognizant. And I know that if you guys refer to the webinar that Gloria and I had done previously, you'll get a very thorough discussion of that section 44. And we've gone through this really prescribed process. This is, in my mind, this is how we're generally approaching day school files at the ICLC now. We'll go through this, take the time to establish a rapport with the survivor. I can't stress that enough. A lot of times they walk in, they've never shared their story with anyone in their life, not siblings, not their parents, never their children, essentially. It's really, really difficult. I found that I have a great time in establishing that rapport just by discussing some of my own family history, or let them know why I've been drawn to do this kind of work. If you can really convince them that you're in this work for all the right reasons, really to help this client heal, essentially, that can go a long ways. Also, don't be afraid to discuss colonization openly with your client. Mention your misgivings about this settlement. It's a perpetuation of colonization. Own that. Have that conversation with them. I think that you're going to find that they're going to trust you that much more by the very fact that you can acknowledge that. We get to the discussion of the availability of therapeutic resources. This should be something that you're going to do before you even start that conversation. You guys have seen the number on the claim form. You can also compile a list of local resources, or, if you're working remotely as we are, and you might be dealing with a client out of province, perhaps, try to locate some of those resources that are in their immediate area. That would be a great step. Okay, number 3, advise your client that they have significant control over the process and can take breaks as needed. Again, we have to be very mindful of the fact that for a lot of the survivors, all their control over themselves and any of their interactions was taken from them. They were seldom in control of anything. Very little autonomy going through that day school process. I've yet to hear of one client coming through thinking that they really did have any autonomy in their life, which is really sad. Number 4, send drafts of the narrative to your clients so you can clarify and make revisions throughout the process. Again, we are encouraging everyone to meet multiple times with with a survivor. I always encourage them, as you see in number 5, to keep a pen and pad with them to write down their memories. This process, I guarantee you, does bring up suppressed memories. That's been the case in almost every single one of my clients, whether it was in the form of nightmares or whatever. Things do come flooding back. I personally don't try to resolve this narrative process quickly. I think I've been working on this since January, and I've only finalized maybe 1 or 2 of my claim forms. Part of this is from waiting to see if we get anything back from our ATIP requests. Otherwise, they really have time to digest what happened to them, and maybe they open up that line of communication with someone who attended school with them or with their family, and they can develop even a better understanding of what they've been through. And sometimes a sibling might mention this one teacher, and just the name of that teacher or a description of that teacher can bring these new memories to the surface. So that's something to be mindful of. Number 6, we have, although the focus of the assessor is on harms incurred at day school, expand your narrative to include a greater history of the survivor. Gloria has done a great job discussing that so far. This is the thing that gets lost again in that harm assessment chart that comes on the claim form. There's very little to steer the claimant, or I would venture even the assessor, as to what this would actually include. For instance, what are some actual psychological harms that perhaps they should allude to? I know Gloria did a great job of mentioning that inability to, maybe continue on with their education or gain some secure employment. A lot of times when we sit down with the survivors, these harms, they're completely lost to them. They don't consider this at all. The way it's presented on that form is physical abuse, sexual abuse, right? This is very much in their mind. And the way it's presented in that harm chart again, this is where you can see that claims start to elevate when you get to these worse harms. But getting lost in the shuffle there is all the nuance of what's the difference between a level 2 and a level 3 harm? If you look at it, you can look at the physical abuse and then causing the emotional or psychological impacts, right, that are long-term. That's why that section 44 is really, really useful. And again, go through your client's entire life history. It's essential. Number 7, we have humanize the survivor in your narrative. I can't stress that enough. We want to present a very idiosyncratic portrait for the assessor of this. They need to know that this is an actual human being who has suffered these vast harms, right? I will use their preferred name. I will use a nickname if that's what it is. I'm going to take the time to mention their spouse's name, their children's names if possible, how many children, how many grandchildren, what it means to that person to maybe be a grandparent after having to deal with that intergenerational trauma and the breakdown of their own family, to bounce back and, maybe become a devoted grandparent. I think that's essential to really paint that portrait of that human, right? Number 8, we have end your meetings on a light note. Again, I do this pretty much with every survivor. Now, that being said, the caveat, I've come to learn that multiple of the survivors I've worked with, they didn't even go on to have a single romantic relationship in their life, let alone have children. But for those who do, the best thing to do at the end of that meeting to put a big smile on their face is to mention their grandchildren without fail. That puts a smile on their face, and they would be happy to speak with you endlessly about that perfect grandchild of theirs. Let's go on to the next slide. Witness statements. Okay, now this is a very, very tricky part. Now, this is something that wasn't actually anticipated in this class action settlement. Now, although for levels 2 and 3, I believe, they say they would like to have these witness narratives. Now for levels 4 and 5, they say that these are mandatory. Of course, in lieu of this, they want you to rely on a sworn declaration. My experience so far is that it can be quite difficult to get a witness for these narratives. Some of my clients, they are the last living individual to perhaps have attended the day school where they went. And, they might have not spoken, well, the vast majority, in fact, haven't spoken about their day school experiences to even their own family. So that's really something to consider. Now, the other thing, there's some ethical considerations here. We have a fiduciary duty to our client. Now, when we're told to step aside from that and get some corroboration for these harms that they've discussed, how do we approach that without sharing our client's personal, highly sensitive experiences? That's something that wasn't anticipated. There's no guidance within that settlement. So we kind of had to do some deep thinking about this process on our own. So if we could go to the next slide. So we have another prescribed process here. So consider the relationship between the client and the witness. So in many cases, people have attended day school with their siblings. Now, that being said, that doesn't mean that they've ever taken the time to share their experiences. In fact, I've noticed that many times they've actually suffered in silence and made the assumption that they might have been the only one at that school to have been abused. And perhaps a sexual manner is usually the most sensitive. So don't take it for granted that just because they say they're close to their siblings, that you can divulge all this information to a sibling if you're using that sibling as a witness for your narrative. Just a second, let's see. I think that's good for that. So number 2, do you have your client's permission to discuss deeply personal details? If yes, you're in luck. That will make things easier. I mean, if you feel, or you can ask them that direct question, may I share everything you've shared with me to this witness so I can get this corroboration? That's fantastic if you can. I think that once you've established a real rapport with that client, you're probably going to figure out whether you can cross that bridge and maybe put that out to them. Can I do so? You might find that that client is, really guarded. You might have a hard time getting them to discuss the sexual abuse that they might have sustained, even though in your mind, you can kind of see all signs are pointing to that abuse. It can be very difficult, right? So this is something to consider. Okay, we can go on to the next slide. So number 3, ask strategic questions. Now, this is if we're operating under the assumption that we could not get their approval to discuss everything that happened to them with a witness in intimate detail. So far for me, this has been the case, even with siblings, is I've never felt like I was quite there that I could discuss maybe all the sexual abuse that they might have sustained. Again, it's extremely sensitive. It's shocking in a way when you think about it that they've even gone so far as to share those details with you. It's awful to think about, right? Okay. And another thing to think about here is how difficult is it to get that corroboration? When this goes to the assessor, are they really considering that? Are they considering the lengths of re-traumatization to this witness? Oftentimes, it's not lost on me when I approach one of these witnesses that I am re-victimizing them. I'm making them go back in time to think about all these dreadful things that have happened to them or that they witnessed happen to other people. And, in many cases, they don't have anyone assisting them with their own day school claim. So that's actually something that's led to us opening a few more day school files at the ICLC. It's just because I couldn't quite leave that meeting with them feeling all right about things. So, the offer to be able to assist them with their own day school claim, that's huge. And I would recommend it if you guys have the capacity to do so. Again, this is every bit as traumatic for them as it is for your client. In some cases, maybe even more so. So then we get into drafting the witness narrative. So you guys will see in the next slide, I've got a sample there. But before we go there, I'm just going to discuss the approach I've taken. Now, Gloria's mentioned doing it by way of affidavit, which that can be really, really powerful. An approach that I've taken with several of my witness statements so far is to take that original narrative of my client and intersperse it with a narrative from this witness, right? And I find that it's easier for me to draft it this way. I think that it's going to be more streamlined for the administrator or the assessor to digest when they're going through these claims. I think it's really powerful also to read that through. And, certainly some details you're not going to be able to corroborate, but you can also speak to why that might be the case. And I think that's really crucial. So moving on, number 5, produce a redacted witness narrative again. So I take that witness narrative, in fact, and what I'll do is I will just delete full sections from my client's narrative. When I present that to the witness, they're able to see everything that I've got on record of them saying. They're able to take that and make revisions. We review this just as you would with the normal narrative. Essentially, all the prescribed process from doing a client's narrative applies to these witness narratives. Although with the witness narratives, with that additional layer of complexity, you can see we need another prescribed process to consider these things. So yes, delete those big block quotes, present them only the information that you've got them on record saying, and make those revisions from there. Let's go ahead and let's look at that sample. Caity, if you don't mind. So I will read this to you guys because it might be a little small in some of your screens, I'm not sure. So these are obviously fictitious names, although other details are coming from one of the narratives that I've done. So Chester, this would be the claimant. Fraser, the other name there, that would be the witness. So this is the way I've approached it. So we have, with respect to the sexual abuse Chester sustained while he's at day school, Chester recalls how Dr. Jack Gifford made unwanted advances towards him when he was aged 12 to 15. As stated by Chester, he told all the other kids to leave the class and then started hugging me and trying to put his hands on me. He put his hands on my knee and on my body. I could smell alcohol on his breath and I sensed it wasn't good, and I told him that I had to go. He knew that I wasn't going to put up with it. But I can remember him getting other kids. Sometimes he would get them to go to his house. That said, although Chester was able to avoid Dr. Jack Gifford's sexual advances for the most part, Chester had stated that many other students, including his brother Nigel, were not so lucky. And he recollects Nigel spending time at Dr. Gifford's residence and notes that there are many witnesses who know about it, Dr. Gifford's sexual abuse. I knew my brother spent time with him where he lived, says Chester, but I never told my mother and my dad anything about that. I kept it to myself. To this day, this is one of Chester's biggest regrets. Then, upon speaking to the witness, being very tactful in the way that I can ask questions about this stuff, I was able to get some corroboration. So we have Fraser substantiates Chester's allegations against Dr. Jack Gifford and notes that it is well known in the community that Dr. Gifford preyed upon children at the day school. That said, Fraser recalls one occasion in which Nigel detailed the abuse he suffered at the hands of Dr. Gifford and other staff at the day school. Fraser recounts Nigel's story as follows. He, Dr. Jack Gifford, caused a great amount of damage to the community, not just to the sexuality of the young men, but to their psyche. We played basketball together, Fraser and Nigel, and I knew he was a homosexual. And one day he told me how it started with him, the genesis of it all, before he could think critically and make decisions of his own. He told me, I stood there while the people abused me. They, day school staff, onlookers, laughed at me and the blood running down my legs. He did not tell me how old he was when it happened. Okay, we can go on to the next slide. Okay, prescribed process. So one of the, again, because the complexity and the ethical issues surrounding the day school witness narratives wasn't really anticipated in the settlement. One thing that we'll be doing with each claim form that we submit that includes witness narratives is we are going to request that the witness narrative be destroyed rather than returned to the client or submitted to the legacy fund. That way we can protect some confidentiality for the witness and, if necessary, for the client. So if this is the case where your client has a completely transparent relationship with their witness, obviously this doesn't really become necessary. I mean, they're an open book in that case. But I find that that's exceptionally rare as of yet. So one thing that we're doing is we're going to draft a letter and we're going to submit this as a request along with the rest of the claim form that that witness record be destroyed. This is in the case that the claimant might want the copy of these records sent back to them. That's why. We're happy to take more questions about this kind of stuff. I'm cognizant of the time. It's already 3:30. So let's move on to the next.
Okay, thank you so much, Jaden. So I'm going to do the next piece here, and I'm trying to figure out how to turn my video back on. So bear with me. There we go. Jaden and Gloria have both already touched on interviewing, and I'm also cognizant of the time, and we do want to leave time for questions. So I'll try not to be too long with this, but there are a couple things that I thought might be helpful to share. These are just some general tips for trauma-informed interviewing. First one here, listening. It may seem kind of silly and obvious to point this out, but as I think Jaden and Gloria might both have mentioned this. In a lot of cases, you may be the first person that the claimant has told about the harms that they experienced, and there's a power in bearing witness to trauma. And so a big part of what you can do for that person is to just be there with them and listen to their story, and be a part of that truth being shared. Secondly, it's really important to just be patient and comfortable with silence. When folks are talking about trauma, people will process in different ways, and giving space and making it comfortable and okay for somebody to, take a couple moments, whether they're crying or they just need some time to collect themselves, can help, make that space as comfortable as possible, to talk about those really challenging things. The third one here, ask open-ended questions. This is a great way, I think, to start to allow the claimant to direct the way that their story or their narrative is going to come out, and to sort of, be in control of the way that information is shared. It is by, virtue of just the class action process that, you will need to ask some more pointed questions, where you need to get details of specific events. But being open-ended at the start just gives somebody the space and the control over how they share their story with you. And that kind of connects us to the fourth point that I've got on the screen about letting the interviewee be in the driver's seat. When folks experience trauma, whether it's physical, emotional, or sexual, those abuses are fundamentally situations where control has been taken away from them and bodily autonomy has been taken away from them. And so something we can do to counteract that is to give as much control as possible to the person that you're talking to. So letting them control, whether maybe it's going to be, they're going to tell you their story in one long meeting, or multiple short meetings, let them determine what that looks like. And that, can be a way of giving somebody control back over that traumatic incident or those experiences. Jaden and Gloria both have talked about building rapport. Trust with somebody is earned, and you have to build trust in order to let them have the space or to build that safe space for sharing. And so I love Jaden's comment about talking about grandkids, and I totally have, had that same experience. Talk about those things, talk about, what they've done that day, what they're going to do, be human people with each other. And that can go a long way. It's really important. I mean, it may be hard depending on your capacity or the way that your practice is organized, but do try to give as much time and flexibility as possible with these interviews. You don't want to rush somebody out of their office after they've made a disclosure of abuse. It's not safe for them, and it's not going to help with that, building of trust. So, try as much as you can to space out your meetings, and make sure people have ample time to share and take as much time as they need. I think, this is fairly straightforward. See the whole person, not discrete legal issues. Try not to get caught up in looking for, you've looked at the schedule of harms, try not to get caught up in minimizing or making things sort of just points to add to the narrative or the claim, points that will help them get compensation. That's not how people experience trauma. And, and I think, another piece of this, which Jaden has mentioned, is allow the narrative to be a broader story about their life, as opposed to just, points of here are these traumatic experiences. Be mindful of your body language. So much of our communication happens through body language. So don't underestimate the value of nodding along, of, making affirmatives. It sounds as you're talking, like, just be a person. That's it can be really important. And be mindful if you have, some people naturally may have, more standoffish body language, and just try to be mindful of that so that, you're opening up to somebody and creating a safe space. Be self-aware of the way that you hear information and handle it. So this, I've experienced this all the time. I'm a sympathetic crier. So if somebody starts crying, I almost definitely will start crying too. And I try to let everyone I'm interviewing know that. I have found with day schools and 60 Scoop survivors that if I start to cry, they take responsibility for that, and they end up apologizing to me that their story has made me cry. I want to try to avoid that as much as possible, and not put that burden on them. And so just letting them know, no, actually, this is just who I am. It's a natural thing for me. It happens all the time. I can't see somebody cry and not cry as well. So, just be aware of things like that. Talk about self-care and support. And so something I like to do at the end of every interview is have a conversation with that person about what they might do that day to take care of themselves. So, even if it's just they're going to go home and make a cup of tea, or, go for a walk with a friend or something, just be open to having those conversations so that they know that they have a right and they're entitled to seek out support and care, because what they've just, been through in sharing their story with you is a challenging, exceptionally challenging thing to do. make referrals where appropriate. As lawyers and advocates, we are not mental health professionals. So, careful not to take on the role of a counselor if you're not trained to do that. It's not in the best interest of that person. But, have a conversation about mental health resources that might be available in the community. I have uploaded to the Sketch page for this presentation a set of mental health and counseling resources for folks, Indigenous folks who've disclosed trauma around residential schools, day schools, 60 Scoop, missing and murdered Indigenous women. So you can take a look at that. I apologize, it's mostly focused on Vancouver because that's where I've been working at Atira. So for folks in other places of the province, it may not be as relevant, but there are lots of online and phone resources that you can check out as well. Be transparent about your interview process. So if you're writing notes, explain why you're writing notes, explain what you're going to do with those notes once you're done, reassure somebody that you're going to destroy them or that they'll be kept in a confidential place. If you're typing, explain why you're typing. All of that just helps, again, create comfort and safety within a space. And then really just encourage folks to be mindful of vicarious trauma. Even in just listening to the example that Jaden shared, around the witness narrative, those stories, like even in that moment, I felt that, and I'm sure other folks listening did too. We can't, support claimants and help them through this process if we're not also taking care of ourselves. So, you can, there's lots of resources online around vicarious trauma. Just, be mindful and take care of yourself so that you can continue to do the work that needs to be done. I wanted to make a couple points, specific to doing these day schools interviews. It's really important to understand the historic context of Indian day schools in Canada. That it's part of that same story around residential schools and the 60 Scoop and really the ongoing impacts of colonization on Indigenous families and communities. So that link there, and folks will have access to this PowerPoint, that link goes to Jaden and Gloria's Courthouse Libraries webinar. And they do talk about the history of day schools. So really encourage folks to watch that. Also encourage people to learn about intergenerational trauma if you're not already familiar with that. The link there goes to the reports from the Truth and Reconciliation Commission, and they talk about intergenerational trauma with regards to residential schools. There are lots of other resources out there, and certainly if people were interested in learning more, I'm sure it's a conversation that myself, Jaden, or Gloria would be happy to have with anybody. Be aware of your own position with regards to the, the topic. I am not an Indigenous person. I'm an immigrant settler on this land. And I need to be really mindful, of the privilege that I have in society as a white person. And the fact that, I will never know what it means to be Indigenous. And so, try to hold that with you if you're a non-Indigenous person and you're doing this work. You need to be mindful of the ways that, you may have, unrecognized bias. And it's, racism and colonization is still, rampant in Canada. And so, you may have some unrecognized biases that you haven't picked up on. And the best thing you can do is just acknowledge that and focus on learning and trying to be, mindful of that. So do a little bit of examination of yourself and the position that you're in, in relationship to that person that you're interviewing and the experiences that they've had. Gloria and Jaden have also both talked about this. The class action doesn't specifically, like the claim form doesn't specifically ask you or ask somebody to talk about healing and resistance. But this can be a really great way to, to combat some of the negative impacts of re-traumatization that happens when people talk about trauma and abuse. And it's also, an important thing to be aware that mainstream narratives in this country often frame Indigenous people as victims. And you can counter this by focusing on somebody's strength and their skills as a survivor. It's an incredible thing that folks went through, really truly horrific things as children, and every single student at a day school, is a survivor in their own way, and you can help them recognize that. And then again, Gloria also has talked about this. I really do think that the best thing that you can do for somebody is to create a safe space for them to share your story. And certainly you want to be encouraging so someone feels that they're able to do that, because it could be that, they think they're a level 1 and they're actually a level 3, or it could be that they're hesitant to tell your story, but there may be an aspect of healing and talking about it. But the flip side of that is that, every claimant drives the bus in terms of how to move forward with their own claim. And so if somebody has decided that it is not in the best interest of their mental or emotional health to share their story, and that they want to do a level 1 claim just so that it's done, and they can move on, then respect and honor that decision and support them through that. I also really encourage folks, I just put up a link to Myrna McCallum's podcast, The Trauma Informed Lawyer. Myrna is a Métis Cree lawyer working in Vancouver, and this podcast is in collaboration with the Canadian Bar Association, and it's really helpful. And there are multiple episodes of the podcast that talk about, how to be more trauma informed. So encourage people to check that out. It's a great resource. Okay, I'm actually going to pass it back to Gloria then to talk about a couple more pieces.
Thanks, Caity. The next section, we're just the next 4 slides, I believe, we're just looking at information that might be requested if you've already submitted a claim and what you can do after the fact. So if you receive a letter that's asking for anything, read the letter fully, review what is being asked for, and complete the missing information form, sign and send it back to the claims administrator. So most of the times when they are asking for information, they are very specific about what they need. And that's been my experience with all of the additional information forms that we get. They're very specific. And so when clients bring them in, I just say, okay, this is what they're asking for. I can help you prepare this. If this is a statement that they want, or if say they're looking for, a witness statement or something like that, then we just simply do what they're asking for and send it back in. And so that's just really just answer the questions that are being asked and help our clients to answer the questions being asked. Next slide. I included this is from the website. It's just a time estimate as to what level 1 looks like and what level 2 to 5 looks like. Level 1 can take up to 6 months. And their confirmation is that you will receive a payment letter to confirm that you've been approved. Level 2 to 5, they'd say it can take up to a year, and that these claims are also sent to the Government of Canada. I don't really know what that means, but Jaden mentioned it before, and he might speak to it a little bit at this point. It could be that they are being sent to the Government of Canada because there's certain information that the Government of Canada has access to, and then they can validate the claims. Next slide. There's on this page and the next page, it just talks about additional notices that you might be asked for. And so this is that accompanies the missing information form. There's additional information so that you might be asked for that. You might be asked for a letter, or you might be given a letter advising that your level 2 to 5 claim is being sent to the Government of Canada. Next slide. You might be advised that you have claimed level 1, but that the administrator feels that you qualify for a higher level, or that you've been reclassified at a higher level. This is one of the reasons that we feel that including a very detailed narrative is important, even at level 1, because at that point the administrator can make that decision that, oh, this is a level 2, or this is a level 3, and then they ask for additional information. So that's why we really encourage our clients to do a narrative. They don't always want to, and so we respect that, but it's for this reason right here. And then the last part, your claim is being sent to the exceptions committee to determine eligibility based on attendance at a non-scheduled K school and or year attended. And so that is just there. They will send you a notice that, you're going on to the exceptions committee. Next slide. I'll send it back to Caity.
Yeah, thanks so much, Gloria. So I'm maybe just going to leave this up here because I really do want to have time for questions. These are just some additional resources for people to look at. So encourage folks to read the settlement agreement. There's lots of important information there. We've highlighted some of the important sections. You can look at the website for the class action. Check out Gloria and Jaden's webinar. Yeah, you can feel free. You'll have access to this, so you can click on all of that and check it all out. And on that note, it's all our contact information, but we're all here to take questions now too, if anybody has anything.
Thank you so much, Caity, Gloria, and Jaden. That was information-packed and very well presented session. Thank you. And we do have some questions. So maybe I'll start off just with reading out some of the ones that have been posed in the chat. And just a reminder to folks, if you do have other questions, to put them in the chat, or if you want to ask them on video, maybe say video. And we've got maybe about 12-ish minutes here. So we'll ask as many questions as we can given that. So one of the questions is, when they send a notice of intent to reject application, is there a time limit to send a request to reconsideration?
I think that question may be about 60 Scoop, which is fine. I just want to make sure we give the right information because I did pull up that. Now, my understanding is that the timelines have all been extended because of COVID for 60 Scoop. So if someone gets a notice of intent to reject, the timeline will be there in the letter, but my understanding from the information Collective has put up recently is that all of those can be extended. And I'm actually sorry, I'm just not seeing here like a specific timeline. So I'm not sure if Gloria or Jaden knows.
I'm just going to speak to everything Collective has said to us is that even though they give a deadline, they will always extend that deadline. And so they do give deadlines. Usually they say 45 days. They say but if they don't hear from you and if the client then, after 45 days responds, they will still accept it.
Okay, great. Thank you. The next question is, when so as an advocate or somebody assisting somebody, if there's a question about a school, who do we contact? Do they contact the lawyer on the suit?
So you can, everyone's entitled to contact class counsel. And I think certainly they should be able to provide some direction in terms of what to do in that case. But you can also contact Gloria or Jaden or myself for support on that, because I know that Gloria has done claims before with schools not on Schedule K. So my understanding, maybe Gloria, you can say that more about that, but yeah, I'll pass on.
If the school is not on Schedule K, we just include the name of the school as the client remembers the name, and we submit the application.
Right. I think you talked about that a bit more maybe after the question was posed. I remember you mentioning that yeah, they can kind of accumulate and then they'll follow up.
Yeah, just to interject, there's one more important point there. This could have been the circumstance where someone was a day scholar at a residential school. Now, that is something that is part of a separate class action. So if that is the circumstances, they'll want to check out Justice for Day Scholars. So if you Google that, you'll find out more about that.
That's a great tip, Jaden. Thank you. So that's Justice for Day Scholars, if folks want to make note of that. Okay, another, this is a bit of a tip from someone who has lots of experience doing the claims, and they say, when doing the schools, one must make sure that they explore all names and different spellings. For example, Kitsagukla, which has many names and spellings. So good tip. And it looks like Arnie has provided some other tips in terms of navigating the claims as well in the chat. So make sure to check that out if you haven't seen his comment yet. Okay, and the last question that we have from the chat, and again, folks can chime in the chat if they have other questions. This question is, if there isn't a school on Schedule K, a survivor can fill out the form and submit, but the claim will eventually be sent to the exceptions committee? Question mark? Is that correct? Okay.
I think that we're assuming that it will end up in the exceptions committee. That's kind of what they're suggesting. So we just tell people to apply, and we just have to leave it at that and see what happens, see where it goes.
Okay, great. Yes, I think that was more of a confirmation of their thought process. So that's great, Gloria. Thank you. All right. Any other questions for the speakers today, attendees? Perhaps not. It was a very thorough presentation. And the thing that's nice is that people can refer back to this later. And you've certainly provided many resources for folks to follow up with to continue their learning. And you're getting a bunch of thank yous and appreciation in the chat. And I think that and on behalf of the tech support and the Law Foundation who are hosting this, I would extend that appreciation and gratitude to you as well. Thank you for doing this important work and sharing all of your knowledge and experience with us. So on that note, thanks everybody for attending, and thank you to the speakers. And we'll see you all again on the internet soon.